When does a business become legally responsible for your injury? You walk into a business expecting something simple, a quick shopping trip, a meal with friends, a routine visit. Then, in an instant, everything changes. A fall, a collapsing display, a dangerous condition nobody warned you about. Suddenly, you're injured, facing medical bills, lost income, and a question that seems straightforward: is the business responsible? Most people assume the answer is obvious. If the injury happened on the business's property, the business must be liable, right? Not necessarily. In personal injury law, responsibility isn't determined by where an accident happened. It's determined by what the business knew, what it should have known, and what it did about it. And the difference between those facts can mean the difference between a successful lawsuit and a case that falls apart completely. When someone is injured inside a store, restaurant, hotel, office building, or other commercial property, the first reaction is often immediate. The business must be responsible. After all, the accident happened on their property, but personal injury law doesn't work that way. Simply being injured at a business does not automatically make the business legally liable. In fact, one of the most important concepts in premises liability law is that accidents and negligence are not the same thing. An accident can occur without anyone being legally responsible. Negligence, on the other hand, requires something more. It requires proof that the business failed to act with reasonable care under the circumstances, and that's where many cases are won or lost. Let's start with a simple example. Imagine a customer enters a grocery store during a rainy afternoon. Another shopper walks in ahead of them, bringing water inside on their shoes. Seconds later, a small puddle forms near the entrance. Before employees have a reasonable chance to discover it, another customer slips and falls. It's a terrible situation, but is the store automatically liable? Not necessarily. Now change the facts. Imagine that same puddle remains on the floor for an hour. Employees walk past it repeatedly. Customers complain about it. No warning signs are placed. No cleanup occurs. Then someone slips and suffers a serious injury. Suddenly, the legal analysis looks very different. The difference isn't the injury. The difference is knowledge and opportunity. Did the business know, or should it have known, about the dangerous condition? And if so, did it take reasonable steps to address it? Those questions sit at the center of many premises liability lawsuits. Businesses are generally expected to maintain reasonably safe conditions for customers and visitors. That doesn't mean they must eliminate every possible risk. The law typically recognizes that not every hazard can be prevented, but businesses are expected to identify foreseeable dangers and respond appropriately. When they fail to do so, legal responsibility may follow. This concept is often referred to as notice. Actual notice means the business was directly aware of the hazard. Perhaps an employee saw it. Perhaps a customer reported it. Perhaps management received complaints. Constructive notice is slightly different. It means the business may not have had direct knowledge, but the hazard existed long enough that reasonable inspections should have discovered it. This distinction becomes incredibly important during litigation. Attorneys often spend months investigating how long a dangerous condition existed before an accident occurred. Security footage, maintenance records, cleaning schedules, NOA's testimony, inspection logs, all of these pieces of evidence may help answer a critical question: could the business have prevented the injury? The answer often determines the strength of the case, but dangerous conditions aren't limited to wet floors. Premises liability cases can involve countless hazards: broken staircases, defective handrails, poor lighting, falling merchandise, uneven walkways, inadequate security, unsafe parking lots, malfunctioning elevators. Each situation presents unique legal challenges, but the underlying principle remains remarkably consistent. Was the danger foreseeable? And did the business respond reasonably? Insurance companies understand how important these questions are. That's why investigations begin almost immediately after serious incidents. Adjusters examine evidence, interview witnesses, review records, analyze maintenance procedures. They're trying to determine whether the injury resulted from an unavoidable accident or from a failure to maintain safe conditions, because that distinction can mean the difference between denying a claim and paying substantial compensations. But even when a dangerous condition clearly exists, proving liability isn't always as straightforward as it seems. There is another factor that frequently changes the outcome of these cases, a factor that businesses, insurance companies, and defense attorneys examine very carefully, and in many lawsuits, it becomes one of the most fiercely contested issues of all. That critical factor is reasonableness, because in premises liability cases, the question is often not whether an injury occurred. The question is whether the business acted reasonably before the injury occurred, and that distinction can completely change the outcome of a lawsuit. Imagine a store discovers a spill on the floor. Within minutes, employees place warning signs around the area and begin cleaning it up. Before the cleanup is completed, a customer ignores the warning signs, walks directly into the area, and slips. In that situation, the business may argue that it took reasonable steps to address the danger. Now imagine the opposite. The spill remains unattended for an extended period. No warnings are posted, employees are aware of the hazard but fail to act. A customer slips and suffers a serious injury. Here the argument for liability becomes much stronger. The difference isn't the accident itself. The difference is how the business responded to the risk. This is why evidence plays such an important role in these cases. Attorneys often work to reconstruct exactly what happened before the injury occurred. They review surveillance footage, interview witnesses, examine maintenance records, analyze inspection procedures, and investigate whether the business followed its own safety policies. Sometimes those records help the business, sometimes they help the injured victim, but they almost always become a major part of the legal battle. Another factor that frequently influences these cases is the conduct of the injured person. Many people are surprised to learn that liability isn't always entirely one-sided. Defense attorneys often ask questions such as, was the hazard open and obvious? Was the person paying attention? Did they ignore warning signs? Were they acting recklessly? These issues can significantly affect a claim. Depending on the laws of the state, an injured person's own actions may reduce the amount of compensation they can recover, or in some situations, become a major issue during litigation. That's why premises liability cases are rarely as simple as they appear at first glance. A person can be genuinely injured, a dangerous condition can exist, yet the legal outcome may still depend on dozens of facts that are uncovered during the investigation. Who knew about the hazard? How long did it exist? What inspections were performed? What warnings were provided? What actions did both parties take? The answers to those questions often matter far more than people realize, and that's ultimately the key lesson. Businesses are not automatically responsible for every injury that occurs on their property. At the same time, they cannot ignore foreseeable dangers and expect to avoid accountability when someone gets hurt. The law generally seeks a balance between those two principles. It recognizes that accidents happen, but it also expects businesses to take reasonable steps to protect customers from preventable harm. When they fail to do so, they may be held financially responsible for the consequences. And when they act responsibly, they often have strong legal defenses available. So when does a business become legally responsible for your injury? Not when the accident simply happens, not when someone files a lawsuit, but when the evidence shows that a foreseeable danger existed, the business had an opportunity to address it, and reasonable steps were not taken to prevent harm. That's the line where an unfortunate accident can become a successful personal injury claim. Now we'd like to hear from you. Do you think businesses should be held to a higher safety standard when customers are on their property? Or do you believe individuals should bear more responsibility for avoiding obvious hazards? Share your thoughts in the comments below. These questions sit at the heart of many real-world injury cases, and there's often more than one perspective. And if you enjoy learning how liability is determined, how lawsuits are built, and what really happens behind the scenes in personal injury cases, subscribe and turn on notifications. Every week, we break down the legal principles, courtroom strategies, and real-world scenarios that shape some of the most important injury claims in America.